In England and Wales, life imprisonment is a sentence that lasts until the death of the prisoner. Although in most cases the prisoner will be eligible for parole after a fixed period set by the judge, this period is known as the minimum term, usually a few years. In some exceptionally grave cases, however, a judge may order that a life sentence should mean life by making a whole life order. Murder has carried a mandatory life sentence in England and Wales since capital punishment was suspended in 1965. There is currently no first degree or second degree definition. However, there were 2 degrees of murder between 1957 and 1965. One carrying the death penalty and one life imprisonment. Life imprisonment is applicable only to defendants aged 11 or over. Those aged between 11 and 20 are sentenced to custody for life. Those aged under 18 are sentenced to detention during Her Majesty's pleasure for murder, or detention for life for other crimes for which life imprisonment is the sentence for adults. However, regardless of age, all defendants including those under 18 sentenced to a life sentence can theoretically be held in custody for their whole life if required, and a life sentence can only end if quashed by a judge or the person serving the sentence dies. In addition to the sentences mentioned above, until 2012 there were 2 other kinds of life sentence: imprisonment for public protection and detention for public protection. These were for defendants whose crimes were not serious enough to merit a normal life sentence, but who were considered a danger to the public and so should not be released until the parole board had decided that they no longer represented a risk. These sentences were abolished by the Legal Aid, Sentencing and Punishment of Offenders Act 2012, although a number of prisoners remain imprisoned under the former legislation. When Parliament was considering abolition of the death penalty, there were many MPs who were against the reform, and the deal offered was that former capital offences would always inevitably merit a mandatory life sentence. Accordingly, life imprisonment replaced the death penalty as punishment for murderers, firstly for those whose sentences were commuted and later for those whose crimes were not aggravated, within the meaning of the Homicide Act 1957. To begin with, it was fairly common for those sentenced to life to be released in around 10 to 15 years. As time passed, it came to be thought that longer sentences should be imposed, especially in cases such as the Moors murders, the Yorkshire Ripper and Dennis Nilsen. The Home Secretary was empowered to make whole life orders to ensure that particularly dangerous or heinous criminals were never released. Currently, mandatory lifers serve an average of 14 years, and for other lifers the average has been in decline and now stands at 9 years. Formerly, the Home Secretary reserved the right to set the tariff, or minimum length of term for prisoners sentenced to life imprisonment. However, in November 2000 politicians were stripped of this power in relation to defendants aged under 18. Following an appeal to the European Court of Human Rights by the murderers of James Bulger. In November 2002 a similar decision in relation to adult offenders followed a successful challenge by convicted double murderer Anthony Anderson. Anderson had been sentenced to life imprisonment in 1988 with a recommended minimum term of 15 years. But the Home Secretary later informed him that he would have to serve at least 20 years. The House of Lords ruled that this was incompatible with his human rights. This judgment was upheld by the European Court of Human Rights. Since then, judges have set minimum terms, and only the Court of Appeal or the Supreme Court of the United Kingdom can make any amendments to the sentence. Though politicians can no longer decide when or if a life sentence prisoner can be considered for parole, the Attorney General still has the power to petition the Court of Appeal in a bid to increase any prison terms which are seen as unduly lenient. The Criminal Justice Act 2003 sets out guidelines for how long murderers should spend in prison before being considered for parole. Judges are not obliged to follow the guidelines, but must give reasons in court if they depart from them, whether recommending a lesser or higher minimum term than in accordance with the guidelines. The guidelines recommended that multiple murderers should carry a recommended minimum of 30 years. as a starting point sentence prior to consideration of additional aggravating factors and of any mitigating factors. A 30-year minimum should also apply to the worst single murders, including those with sexual or racial motives in the use of a firearm, until 2015. The murder of a police officer in the course of duty also came within this category. Most other murders should be subject to a 15-year minimum as a starting point. There have been